So let's get into some of the other critiques that Kostas brought up in his piece, because again, his piece focused a lot more on
what the court might do.
Yeah, the practical aspect of the Supreme Court. And we've talked about Bruen. I think you've gone through and given a pretty at least compelling case. Whether everyone's going to agree or not is a different question, obviously. But you've got a solid basis for why you think this was the right decision under the Bruen test as it's been articulated by the court. But there's the question, of how you think the court would actually handle this case. Because one thing to make clear, too, is like this particular ruling is a bit of an outlier. There have been a number of other federal courts that have gone the other way, even since Bruen. So, there's not consistent position from the lower courts on this point yet, which is a very common thing you've seen in the wake of Bruen. A lot of disagreement. Well,
there is a consistent position on denying the right.
Yeah, I guess that's fair.
They always follow the same logic. Mm-hmm. And I think, the question is, when you look at the split, right? Because the split is, on one side, it's, well, they're not part of the political community. Mm-hmm. And then we already touched on that political community thing. I think it's important to stress that, though. And a lot of what, my dear friend Kostas wrote is it hangs back to this political community. And then they cite Heller. And because Heller refers to the political community.
Yeah, that's one thing I was going to bring up is the court itself has talked about this sort of conception of, like Heller, for instance. You're talking about a defendant who was, law-abiding citizen with no, serious criminal record, and they're saying that they mention this offhand in describing the kind of people who are affected by the laws they're dealing with,
right?
In Heller and in Bruen. What do you make of that? I mean, they do talk about it, at least in dicta, in this non-binding sense.
So the political community angle was the Heller court grappling with the opposing justices' contention that the Second Amendment was not an individual right. And so basically we had several pages of the court saying, you're being stupid. Like, look at all of the other amendments that we've dealt with that use the same language and that obviously apply to people. And then they said, like, for example, the Fourth Amendment unambiguously covers all members of the political community. And then the case they cite is one of the interesting cases where something was found not to be Fourth Amendment protected. And that was a search by U.S. authorities of the residence of a Mexican national in Mexico. So the Mexican residents, right? He was alleged to have committed crimes sending drugs to America, right? They said that's not covered by the Fourth Amendment because you have no voluntary connection to this country. So you're not like, why would you be covered by the Fourth Amendment out there? That is not the same thing as what we have here. In fact, it's the opposite. So I think the political community thing was a piece of dicta when the court was saying, you guys are so stupid. Obviously, it's broad. Look, it covers everything except this guy, right? And then they point to that guy. And this is somehow tortured into political community that, like, I don't understand how it got to you need to be able to vote. I legitimately don't understand that. But lower courts have taken that and just run with it because they said, well, Scalia muttered political community in Heller. And so that means the scope of the people in the Second Amendment is different from what it is everywhere else. And I just think that's like, so that's the argument on the political community side, right? Is that, right? And then you look at the argument on the other side, which is, hey, we looked at the historical analogs. We think the how and why is a little bit different. I don't think they carry the day. So you don't have to say one's perfect, but which is the better exercise in reasoning? I think on the side of allowing or not violating these people's rights, I think it stands up better. I think there's less leaps, all right? Like logical equations can be reduced to math problems, right? So in which one is there more question marks? And I think there's more question marks on the it's okay to regulate side.
Yeah, when you look at those mentions in Heller and Bruin of when they're describing the people involved as defendants or plaintiffs, it always seemed to me like they're talking about the sort of, well, if it applies to anyone, it must apply to these people, right? Because there's no question that Heller was law abiding, or that he was a member of the political community, that he lived here, and you don't have any of these questions, right? Like it was sort of like we're deciding this very specific thing on this very core to the basic question kind of defendant, and not that they were saying, oh, you have to be law abiding, whatever that might mean. So it's like or they weren't trying to define what law abiding means. They're just saying this guy clearly is.
If you're getting Fourth Amendment protection, right? I don't think I don't think the Fourth Amendment was written for people who are like habitually law abiding, right? It was a restraint against the government.
Look at Miranda, right?
Right? Like it. So that becomes hyper problematic, and you get all of these bizarre incongruencies if you just insist that for some reason the two words "the people" in the Second Amendment was just a completely different thing from everywhere else. If you insist on that, you break our entire constitutional system. You literally break it. And is it worth it? I don't think it is.
Now, at the same time, right, looking at the court, it's not just a philosophical, institution that creates, law review papers, right? It is a political institution to at least some extent here. And one thing that I think is pretty clear about the Roberts Court in particular is that it prefers not to make rulings that have very sweeping change. Now, it will do this sometimes. Even Bruin is an example of it. But they seem fairly hesitant to do that. They like to try and wait for outliers. I mean, even Bruin is kind of an example of this, because Heller and Bruin struck down laws that were not very popular. There weren't that many of them left. They did it well after the sort of the political zeitgeist had already changed on the issue, like handgun. If they'd said handgun bans are unconstitutional in the 50s or 60s, it might have been a pretty different thing, because the polling back then was much more split on the issue.
It wasn't split. The vast majority of people wanted handguns out.
It was like, if you look at Gallup, I think it was like 60 something, whatever. And then by the time they actually did Heller in 2008, there were really only like two actual bans in the country, DC and Chicago. And the polling had flip-flopped completely on the question. And it's a very similar story when you look at concealed carry, where if they'd done this in the 90s or the 80s, sure, it would have been a pretty aggressive move to defend, the Second Amendment's protections that are offered. But they did it in 2022 after almost every state had adopted some sort of concealed carry law. And the biggest remaining obstacle, there was no outright ban anymore anywhere in the country. And now a couple of those were from court rulings, DC and Illinois, but you get the idea. This is at the end of the trend in the direction towards the country generally approving of concealed carry. Whereas, are illegal immigrants owning guns at the same point? I think it's harder to argue that, right? And so where would you expect the court to actually end up on this? And especially with where you listen to these last couple of oral arguments, and they seem a bit more, they certainly don't sound like a court that's raring to like strike down the NFA or go and take apart the Gun Control Act by any, completely at least. Like they might be a little more sympathetic towards nonviolent felons or nonviolent criminals, and maybe illegal immigrants fall into that that category. I don't know. I'm interested in where you think practically the court is going to go now that we've talked about sort of the legal basis for your thoughts on this, and what you think the right analysis is. What do you think the actual outcome of a Supreme Court case is going to be? And do you even think one's going to get up there? I mean, with this case could easily be overturned at the next stage and never even make it.
I don't think we'll see it anytime soon because this is just too spicy. It's a very hot potato. And I think I really agree with you on how the court has followed the ball on in the gun rights context. Look, after Heller, everything, it almost didn't change anything, right? And we had over a decade of just the same crap happening as if nothing had changed. And the court wanted nothing to do with it. And even right now, the court wants nothing to do with handgun or with hardware bans. And hardware bans are probably the most important thing for right now, next to prohibited categorizations. To me, I think prohibited categorizations are the most important thing. But look at the zeitgeist. We have pro-gun people eating each other right over it. So I don't think this is going to be. I think if we get action on one of these illegal alien cases, it'll be hey, GVR, look at Rahimi, right, or something like that. And I think the ball will be kicked like that for some time, because just from a practical standpoint, the court is aware of, one, its political leanings and its image. And it would also know that I think that if the court were to deny, were to come down in favor of the government in these cases, it would have to dilute the Bruin standard aggressively.
Yeah.
And so they're going to make a tactical decision, which is we don't want to do this, right? Likely because we are scared of immigrants. So let's just not.